because advocacy is not measured by the volume of one's voice, but by the clarity of thought, not by the length of submissions, but by their precision, not by evasive or evasion of question, but by the ability to engage with them honestly and intelligently. The finalists demonstrated commendable composure under pressure. They were tested not only on their knowledge of law, but on their ability to respond, to adapt, and to assist the court. And that, in essence, is what advocacy truly demands. Dear participants, what you have experienced here is invaluable. A textbook may teach what the law is or what the law says, but voting teaches you how the law is applied, how the law is interpreted, and sometimes even challenged. In the courtroom, there are no rehearsed answers. There is only preparation, presence of mind, and clarity of reasoning. And over these past days, you have taken a significant step in cultivating all these things. I would like to reflect upon the role of a bench in a moot court. Our questions were not meant to unsettle you. Really, we had grilled you a lot, but they were not meant to unsettle you. They were not interruptions. They were invitations. Invitation to think deeper, to justify your proposition, and to reconsider them if needed. And I must say, you rose to that challenge with remarkable maturity. To the organizers and faculty of the Department of Law, DGIM, you have created a platform that goes beyond competition. You have created a space where young minds learn the discipline of law, the ethics of advocacy, and the responsibility that accompanies both. But such initiatives are essential not merely for academics or academic development, but for strengthening the very foundation of legal profession. My dear students, as you move forward in your legal journey, remember this. The profession you are entering is not merely about knowledge of statutes or precedents. It is about responsibility. Because one day you will stand in real courtrooms where your words will not only be hypothetical, they will affect rights, liberties, and lives. And in those moments, what will matter is not how much you know, but how well you think, how clearly you can present, and how responsibly you can say or act. Also remember, success in a moot court is not defined only by winning. Some of the most meaningful lessons come from moments of difficulty, from questions that you could not answer, the questions which you decided to overlook or bypass, because maybe that you were not well prepared to answer that. You just slowly overlooked. And it's hard. Those moments define you. They prepare you. They stay with you. As we conclude, let me share a simple reflection drawn from what we witnessed in the finals. Moot court is not a contest of speaking. It is a discipline of thinking. It is not about impressing the bench, but about assisting the bench. It is not about it is not about defeating your opponent, but about strengthening the cause of justice. Before I conclude, allow me to leave you with this thought. A student studies law, but an advocate serves law.